I want to talk to you today about the Andary versus USAA decision from last week. This is a really important victory for car crash survivors. It will stop people from being denied medical care based on the insurance company's deliberate and very intentional misinterpretation of the changes to the no-fault law that were passed in 2019. First, a little background. In 2019, Michigan lawmakers changed the Michigan no-fault auto law by adding, among other things, a no-fault fee schedule and changes to our attendant care. The fee schedule limits how much doctors and providers can be paid for caring for car accident victims. The new no-fault law also slashed by nearly 1/3 the amount of in-home family-provided attendant care that would be covered by auto no-fault insurance for catastrophically injured victims whose doctors were prescribing this attendant care. So here's the rub. Starting in July of 2021, auto insurance companies began to apply this new law retroactively to people whose car accidents occurred before the legislature even passed this new law. I know you're not supposed to say, "I told you so," but for readers of my blog, I told you so. I've been saying for a very long time now that the case law in Michigan is very clear. Substantive vested legal rights based on insurance policies and car crashes that occurred years before a car accident cannot be taken away by a new law that wasn't written and didn't even exist years into the future. This was, from the beginning, a disgusting, unethical tactic. Insurance companies claimed this uncertainty to try to boost profits, to deny clearly legitimate claims, and to withhold medical care from crash survivors. They also used this uncertainty to contact people who were already receiving attendant care and try to negotiate new hours and new rates, basically extorting people to accept these new hours and these new rates because the implied threat was the new law allowed them to deny all attendant care over 56 hours a week. You don't have to be a lawyer or have gone to law school to see the obvious here. Applying a new law that didn't even exist retroactively to people who bought insurance policies years and years before and were injured in car accidents years and years before is incredibly unfair and extremely prejudicial. All this highlights a broken system. Anita Fox, the director of the Department of Insurance and Financial Services director, stood by and did nothing while survivors suffered due to a lack of receiving necessary medical care and attendant care. The lawmakers in Lansing and Anita Fox, the head of DIS, stood by and did nothing as these insurance companies sent out hundreds of these blackmail extortion letters to all these catastrophically injured people all around Michigan, trying to use their own completely baseless misreading, deliberate misreading of the law to try to get these people under extreme duress to voluntarily agree to these drastic cuts in hours and rates. And they're standing by, these lawmakers and unfortunately the people at DIFS, even now, as insurance companies are doing the same thing all over again, this time with billing. And yes, State Farm and MEMIC, I'm looking at you and I'm talking to you, where you're now taking this completely untenable position that the lowest possible rate around that you find is now the reasonable and customary rate. So what they're doing, these insurance companies like State Farm and MEMIC, is they're using Medicare and Medicaid rates and claiming that the new no-fault fee schedule is at most the ceiling, the absolute highest that a provider can be paid, and that the lowest rate they could find out there, throwing out all the other rates, is the rate they should pay. So last Wednesday's actually, Andary versus USAA ruling is a really important start. The Michigan Court of Appeals confirmed just exactly how baseless the insurance companies have been with this ridiculous retroactivity argument. I would say, to summarize, the key holding of the Andary court is that the no-fault fee schedule and attendant care limitations cannot be applied retroactively to survivors who were injured before the effective date, which is June 11 of 2019, of the 2019 no-fault changes, for these two important reasons. Number one, lawmakers, when they drafted and enacted this new law, said nothing in the new no-fault law about wanting this to be applied retroactively. And number two, the no-fault fee schedule and attendant care limitations applying these retroactively would substantially impair no-fault insurance contracts that were entered into before the new law and the amendment's effective date, which would therefore violate the contracts clause of the Michigan Constitution. So the Court of Appeals ruling in Andary makes both common sense and legal sense. Unfortunately, what makes no logical sense whatsoever to me is why lawmakers and DIFs have allowed these auto insurance companies to disregard and distort the law for this long. I've received a lot of questions since last Wednesday from car accident survivors like Arnie and many others who've asked what's going to happen now and who've been receiving less than they should be for attendant care. So to me, the key is this. After a published Court of Appeals decision that is now directly on point, these insurance companies can no longer tenably say that the law is still unclear. So I hope this helps, and please reach out if you have any questions.